Welcome to Springlaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. Springlaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning. My name is Lisa Stam. I'm one of the lawyers here at Springlaw, and presenting with me today is my colleague Ben Currie. Thank you for joining us today for this super glamorous topic of HR law compliance, everyone's favorite, I'm sure. As many of you already know, we are employment lawyers and contract lawyers in Canada in our virtual law firm. Welcome to those of you that are new to our webinar. Throughout the next hour, please feel free to ask any questions you may have in the chat function. We'll be keeping an eye, so if my eyes are darted off, I have another monitor here ready to go. Feel free to download our slides in the handouts tab, and then if you need any more information about our law firm, please come visit us at springlaw.ca, where we have a variety of resources, including our award-winning weekly blog posts about employment law issues, our free policy compliance checklist to give you a bit of a head start on what you may need to do with your policies if there's any gaps, a link to subscribe to our monthly newsletter, and then information about our innovative subscription program for employers and our DIY legal products. So come on to our website and check it out. Here is a lovely picture of my colleague Ben, and let's jump in. I think I just want to make sure everyone is popping in. I still see some people coming in, so maybe I shouldn't rush too much to get started and give everyone a chance to get in. Okay, I think I will start. Okay, before, of course, we start, I do want to acknowledge that we are on the traditional territory of many nations, including the Mississauga, the Anishinaabe, the Haudenosaunee, the Chippewa, the Wendat, and the Mississaugas of the Credit, and that this territory is now home to many diverse First Nations, Inuit, and Métis people. We have to start every webinar with a disclaimer because we are lawyers, and this is all legal information, not legal advice. Here is the fine print, should you wish to learn more about how this is legal information, not legal advice. All right, let's jump in. So today we're going to talk about the required policies, required training, additional obligations, required postings, and then have some takeaways. We're going to focus today on the must-haves that you need to comply with your HR law obligations. There's so much noise online about the millions of initiatives that HR professionals and business owners can launch to make their business better. Today, we are focused on the legally mandatory stuff, so the stuff that you have to do just to help you cut through that noise. A quick note on jurisdiction. We do normally advise employers across the country, including in Quebec through our colleague in Montreal, Vincent Haas-Desmarais. Today, though, we're going to focus on Ontario and on Ontario business that speak to the specific legislation in Ontario. The concepts will apply regardless of what province or territory you're dialing in from, but you'll need to check with your local specific statutes about the specific nuances. We can certainly help with that. It's very similar across the country, so that, you know, it's not all that different. But we are going to be referencing Ontario-specific legislation today, which we don't normally do, but we will be doing that today. Ben, over to you to tell us all about required policies.
Exciting topic. Good morning, everyone. So as Lisa mentioned, we're just going to be talking today strictly about policies that are required and employment related in Ontario. So there's lots of must-haves, but these are just the ones that are absolutely required. For many of these policies, they're only required if the employer has a specific number of employees in Ontario. So we'll of course highlight that just so you're aware if the threshold is met for your business. And we'll also talk about what these policies require and what they don't require, because there is some common misconceptions out there for a few of them, along with the source of where they come from for reference if you wish to learn more than what we covered today. So just at a high level, we're going to talk about electronic monitoring and disconnect from work policies. These both come from the Employment Standards Act and are quite recent in the last 2 years. We'll also talk about workplace violence and harassment and health and safety policies. These come from the Ontario Occupational Health and Safety Act. And finally, we're going to talk about accessibility, and this comes from the Accessibility for Ontarians with Disabilities Act. So jumping right in, the first one we'll talk about is the electronic monitoring policy. And this came into effect on April 11th, 2022, and this was from amendments to the Employment Standards Act in Ontario. So when that first happened, the first threshold was that employers had until October 11th of 2022 to implement this policy. Most importantly, it does only apply to employers that have 25 or more employees in Ontario, not elsewhere, like some other requirements. This would capture, however, multiple locations. If there's 3 or 4 locations, for example, of the company within the province of Ontario, all would be added together to reach that threshold. As we note here, the requirements for this policy are really that you describe how and in what circumstances you're monitoring employees and the purpose that's being used for. One thing that we always advise employers when drafting these policies is that electronic monitoring is very broadly interpreted from employment standards. Although it's not defined, they do provide some guidance in terms of how they're going to look at this. And it's not just things like video surveillance and obvious forms of monitoring, but really any form of monitoring, for example, key card access to enter a building, whether there's any keystroke monitoring of work email, those types of things. So we always brainstorm with clients just to make sure that we're capturing all those various forms of monitoring that might be necessary to include in this policy. One important thing to note, however, is that when this first came out, there was a misconception that this might create some additional right to privacy for employees, and that's not the case. The requirement that's enforced is to have a policy that meets the requirements here, to be fully transparent about how and why you're monitoring employees, but it's not an opportunity for an employee to go to employment standards and say, you know, this is unreasonable, it's a violation of my privacy. There's no additional privacy right created by virtue of this requirement alone. It's really just that you have a policy and it meets the requirements that are specified here from the Employment Standards Act. So jumping right into another one, disconnect from work. This also comes from the Employment Standards Act in Ontario. This was added in December of 2021, and employers had until June 2nd, the following year in 2022, to have this policy in place. Similar to electronic monitoring, it only is required under the ESA if the employer has 25 or more employees in Ontario. So just want to flag that again, just in case there are smaller employers on the call, just so it's clear that this may not apply to your workplace. Unlike electronic monitoring, the ESA is actually quite general and vague on the requirement with this policy. There's no actual policy requirements other than to have one, which I appreciate sounds kind of strange, but really, quite simply, the requirement is that the employer has a policy related to disconnect from work, and that's quite simply where it ends. I'll note again just that this does not create any legal right for the employee to be free from work outside working hours, or, you know, for example, to bring a complaint to employment standards and say, my employer contacted me at 5:15 and my shift ends at 5. I want some damages or some kind of remedy. With that said, we do always say to be a little cautious with what you put in the policy and how far-reaching it is, because if it is a greater benefit, there is a possibility that employment standards might try to enforce that. So, for example, like we might say, you know, these are your core working hours. We want you to take time outside of work. However, there may be situations that arise where we will need to contact you in, you know, exceptional circumstances, something along those lines. You just don't want to overcommit too much and end up agreeing to more than you expected to.
Yeah, when this first came out, this one, I know there was a few more hardcore employers that were a little disappointed that this doesn't allow employers to require employees to work 24/7. But equally, as you say, employees, it's not a protection to employees to say that you can never have me work, you know, after 5. So it's at the point of this is write it down and manage expectations. I think that's the key takeaway for both of these. Ben, we got a question in that is related to both of the electronic monitoring and this disconnect from work. would this apply to a company with salespeople who don't get paid but are treated as employees? So independent contractors, let's say that. So it's how do we define employee in both of these pieces of legislation?
Yeah, that's a good question. So the independent contractors, if they are truly independent contractors, would not be covered by the Employment Standards Act. That's a difficult distinction to make. A lot of times when we talk to clients in more detail, they might call them contractors, but then we find out that when we ask further questions, they might look a bit more like an employee. Probably the easiest way to make that distinction would be to say, if they're an independent contractor, they would not be included in that threshold. To determine if they are an independent contractor versus an employee, the things that an adjudicator would look for would be, the level of control. Are they kind of, is the employer or the company dictating when they come, what type of work they do, and maintaining quite a bit of control over the workplace and the terms and conditions? Or is it truly a contractor where they're not exclusively relying on you as the employer for work? They work for several different companies on the side, those types of things. So if there's any question as to whether they're a contractor, those are the types of factors that we would look at. And I guess, again, just to provide a simple answer to the question, if they're contractors, they don't count in that 25 employee threshold that we mentioned.
And if they are being treated as employees, then that opens a whole big can of worms. It's they're one or the other, and CRA and the Ministry of Labor, everybody likes them to be employees because it's more tax, more protection for employees. So if they're being treated as employees, I would be careful and get some advice on that for sure.
Absolutely.
Yeah. Okay, workplace violence and harassment. So this came from a bill that was passed back in 2009, Bill 168, and this was called, and is still called, Bill 168 all the time, even though there have been many Bill 168s since in each new season of the legislature. But this was passed back in 2009 to really beef up everything around workplace violence and harassment. It came out of an inquiry in Ontario of a horrible situation that happened in the hospital, of a murder on the front steps of a hospital. It was between a doctor and a nurse who were having a relationship, and it went sour. And anyways, it's a very sad, long story. And what came out of that over a few years was this very robust amendments to the Occupational Health and Safety Act. So there's a whole new section in there, well, not new anymore, it's over a decade old now, but this section in there around workplace violence and harassment. It was always part of OSHA that you cannot harass people, and that was always covered, but it really clarified and deepened the definitions of everything. So the definitions of workplace harassment, for example, very broad. It's a course of conduct. It focuses on whether the recipient is, if it's unwelcome conduct, for example, whereas, I think there was always attempts at arguments that, well, I didn't mean it, kind of arguments in the past prior to that. So that shut all that stuff down. The workplace violence definition, you want both the workplace violence and the workplace harassment definitions from the legislation right in your policy. Don't paraphrase anything, just cut and paste it right in. The workplace violence definition is very specific. It's not just violence, it's threats of violence, and it's statements that can be interpreted as a threat of violence. So it is specific and broad. So you want this in your policy for workplace harassment and violence. Typically, we just bundle it in within your whole employee manual. So it does not need to be a standalone, but it'll now be a much longer policy than it was, in the past, because of these specific requirements coming out of the legislation. The other aspects of this is that within the policy, you need to include terms around how the employer must conduct risk assessments if there's any workplace violence. The other notable piece is that this legislation brought in domestic violence as a piece of the workplace violence and harassment requirements. And basically, if the employer knows that, or it's reasonable to know, or reasonably ought to know that some domestic violence may spill over and threaten the safety of employees, either that employee or other coworkers. All the proactive duties under OSHA are triggered. So at the time, that was quite unique to have domestic violence, baked right into a workplace legislation, but that comes out of that history of the legislation in the first place. Other requirements under Bill 168, policy requirements have to include things like reporting procedures for reporting incidents and complaints, investigations, and then reporting the results of investigations. This piece is probably the thing that gets used like 50% of our job is people bringing forward a harassment complaint, not liking the reporting process, not liking the results of the investigation, HR trying to do it in a timely manner, trying to flag exactly what the complaint is and not let it blur out into this giant a giant investigation. So this process piece, it needs to be specified within your policies to really give life to the requirements and to help employers really have this solid procedure to refer to and follow. And finally, it's not strictly required, but under OSHA, under this part of the legislation, but typically we'll see anti-discrimination type policies embedded in this part, right? So because it's married to the harassment piece. Often the harassment, especially if it's sexual harassment, obviously that's a discrimination issue. And so there really is often hard to unpack all of this. So we do strongly recommend that you always have an anti-discrimination policy in place anyways. It's the right thing to do, but it's also tuck it in within this area of your handbook to tie it in with the harassment complaint procedures. I see a question coming in about this. Can you provide more details about violence risk assessments and what level of detail is required to be included in the policy? So the violence risk assessments, there is no specific guidance on that, which is always feels very unhelpful in the moment. It is an assessment of whether or not it is reasonable, whether the facts of the situation, the circumstances of the situation, or the past conduct of the people involved give rise to a concern that there might be a repeat. I mean, I know that all sounds super flaky, but it's that's the requirement. The risk assessment, there isn't a specific formula. And it's hard for employers because if you get it wrong, everyone likes to rely on hindsight in that situation. So the advice that we always give to employers is write everything down, have a common approach that you take to all of these situations. So a bit of a checklist that you go through. Make sure you've asked the key witnesses, that you've turned your mind to the situation, because more often than not, if you let, for example, a frontline supervisor say, oh, no, it's fine, it's no big deal. That is not a risk assessment, that you need to ask more questions, make sure you ask the people involved. If there's a domestic violence situation, I think it is important to and this takes a lot of, sophisticated nuance, but talk to that employee who's facing domestic violence and ask them, is there a risk here? We have all these proactive duties to keep everyone safe, including you. And write it all down. And that's your risk assessment, because we're not talking about hazardous waste, right? That's, under WMIS, there's a really specific checklist for that. This is more, I don't know, what's the word I'm looking for? It's more intangible. Ben, do you have any extra comments on that piece around the risk assessment?
Yeah, I think it's tricky. I think it's just being aware of your specific workplace, talking to the various individuals that are familiar with it and trying to identify any obvious risks, like in addition to what Lisa mentioned. I think that really the idea with this is if there's, an obvious or even a known source of risk within that specific workplace, that the legislation really doesn't want that to be ignored, wants it documented so that there's, an opportunity to build on it and avoid it in the future.
Yeah. And, if you're a big enough company, it may mean moving people or moving them off of, separating people on shifts, even temporarily, to sort through an investigation, for example, until you can really dig into all of the facts. And then the second part of this question is what level of detail is required to be included in the policy? So OSHA does set out in pretty a lot of detail compared to most employment law type policies. This workplace violence and harassment, what needs to go in the policy. AOTA is like a close second, of course, but maybe that's first. There's a lot of details that have to go into the policy. But it's the procedure more than anything. It's a reference to domestic violence, and it's specifying the definitions. Just cut and paste in those definitions. Like I said, don't paraphrase, and really follow the legislation itself. Okay, health and safety. So continuing on with occupational health and safety, this one is a hard one to do because you have to have a health and safety policy, but there is no specific guidance on what should be in that health and safety policy. The Ministry of Labor has some good stuff on their website about what ought to be included. So things like a statement around the employer's commitment to safety, information about we'll get to posting in a moment, so you have to post the act. You know, if you're a large enough employer and you have a joint health and safety committee, posting information about that. But it's not, I always find this one tricky when people say, well, what needs to go in my health and safety policy? It's really, it can be a one-pager saying we're committed to health and safety in your workplace. If you are if you're, let's say the oil sands, but this is Ontario. If you are in a industry that has a lot of hazardous waste or just a high risk, construction or any sort of industry where it's just a different level of safety assessment, then I think you will need more detail. But for the average office worker, this one is it's mandatory, but I would say it's one of the more leaner obligations. If you regularly employ 6 or more workers, you have to write it down and post it. If you're 5 or less, you don't have to put the policy in writing unless you're ordered to by the Ministry of Labor. So it gives you a sense of the depth of this one in particular. Let's see. Does the workplace violence and harassment guidelines vary province to province? So Ontario was the first one that came out with super detailed obligations. So I would say 10 years ago, absolutely. But most of the provinces have caught up with pretty detailed obligations as well, but they will vary a little bit. And so what we often recommend if you're a national employer or even just in a couple of provinces, just pick the province with the highest standard. Ontario tends to be the highest standard for AOTA and disability accommodation type stuff, for example. Just pick that, and then that way everyone sort of rises up to that standard, because there is case law that speaks to if you try and cherry pick a lower standard here wherever you can, adjudicators don't like that. So try and pull everybody up. Okay, I think if we answered all the questions here about these ones before we move on to AOTA. How many employees does a company need to have for a health and safety committee? We're going to get to that, aren't we? I think that's coming up.
Yep.
Yeah, okay, so we'll get to that. Okay, so let's, here's a good one. What kind of things would a health and safety policy need to cover for an employer who is completely remote? Great question. So first of all, if you're completely remote, then you're not going to be hanging all your posters and all this stuff on your bulletin board in the lunchroom. So it's absolutely valid to just have some shared access on your internal wiki or intranet or drive, whatever you call it, and put everything there. So in terms of the health and safety policy, because health and safety includes harassment, that is certainly something that is as much of an issue for employers who are remote as not remote. So for sure you'll want to include that. If people are working in home offices, it's good to include some sort of safety around working in the home office and making sure that it's, hazard free, tripping. I've seen different policies that go into a lot of detail. Make sure there's nothing that you can trip on in your office to try and cover off those kinds of injuries. I think one could go over the top on that a little bit. But this is the issue with this. There isn't a checklist of things that have to go in a health and safety policy. So it's really just being thinking about your own workplace and what could be a risk of a safety risk, a health and safety risk, and throw that into the policy. Anything you want to add to that, Ben, before we move on to accessibility?
Yeah, no, I think those are good comments, and those are questions that I've gotten in the last few months, actually, recently, just in terms of, if it's a virtual workplace, how do you modify these? And the requirement doesn't go away, but those are some good tips that you gave just on, unique things that you may want to include that might not apply to a physical workplace or an office.
Mm-hmm. Sorry, I know I'm jumping backwards, but I'm seeing another good question that's related to this. How can we ensure that a home office space is compliant and safe for the employee? And this is the question of the day since COVID, right? Since March of 2020, I think that has been, we're absolutely in a new era for sure. So I think we're all still exploring this. One thing I think that, our firm is fully virtual and has been since we started in 2017. Everybody has to provide a copy of their home house insurance, for example, or wherever their home office is, insurance. So you can have, if everyone is working from a home office, there's a couple of sort of due diligence things to do. One would be just make it a requirement that people have to provide a copy of their insurance so that you have that as a backdrop. You can reserve, have a remote worker policy within your employee manual, and you can reserve the right to do home visits. Super unpopular term, just so you know, nobody wants that. And I think you'd have to be really hesitant, and it would be a pretty extreme example before you're going to do that. It does feel very intrusive, so I think few would appreciate that at all. Video calls, honestly, just have good communications with your team so that you can just check on people. What is their mental health state? If you see on the video call that there's all kinds of empty Mickeys behind them, then you know that you gotta take unless they have like a cool green screen like we do, then you can't see it. But you can just have good communications to cover off a lot of that. So what goes in the policy? It's a tricky one. You can just start listing what you think are safety issues within the home policy, but we're still figuring this one out, to be really honest. Ben, any words of wisdom on this one?
No, it's tricky. I've seen both extremes where employers want to be explicit about actually visiting the home and inspecting on a regular basis, but I don't know that I've ever actually seen it followed. So I think those are some good practical tips that, maybe video calls and, some direct questions, like maybe checking in, saying, how's your space working? Things like that, most of which you've already covered are a good middle ground maybe to, still address that concern and not fully rely on the employee's word, but maybe not going so far as to doing the home visits, as you say.
Yeah, and I think when it comes to a remote workforce, you want to focus more on the remote worker communications and participation and confidentiality and data security, and there's a whole bunch of other issues that you'll want to throw into a remote worker policy. The health and safety is one of the terms in that policy, but I wouldn't say that it's going to be a whole big separate thing typically. Okay. Here one. Trying to answer questions as we go along. So is providing insurance coverage mandatory? What if they are hybrid? It's not mandatory. This is you can throw it into a contract and make it mandatory when you hire someone. But that is more of a due diligence thing to help employers make sure that there's coverage for any employee injuries in the workplace if it's outside of WSIB type stuff. So I don't know. It's certainly not a legislatively mandatory thing. So I know we're talking about legally mandatory things today. That's just more of an example of a thing that you can throw into your health and safety policy for a remote workforce. Accessibility, and then I'm going to turn the whole next section over to Ben. So the Accessibility for Ontarians with a Disability Act came out in 2005, and it's been rolling out a whole bunch of specific obligations for employers since. And it doled it out over many years, started with public sector and large public and private, and sort of it's given everyone a decade or so to let it unfold. it is, I just want to start with, it is a remedial statute. So AOTA is not a statute, similar to what Ben was saying earlier about privacy and disconnect from work type things. An employee can't bring an AOTA complaint forward. They could file, file a complaint about their employer, but there's no remedy that comes back to the employer. So it's not like you can sue your employer under AOTA. So what AOTA is it's a basically it's the authorities have the authority to go in and see what's going on and ensure that you're complying with the legislation. And if you're failing to comply, it can fine the company, but that's not damages that goes back to the employee, for example. So I think, at first there was a lot of confusion about that. Fairly early on, the Human Rights Tribunal issued a case that clarified, no, if you want to file a discrimination claim on about disability or on the grounds of disability, you do that through the Human Rights Tribunal and the Human Rights Act regime, not through AOTA. So AOTA is a layer of obligation that's put on employers to ensure that, and companies and businesses and anyone who's providing a service to ensure accessibility for Ontarians with a disability. So it's based on the size of the employer, and there's a big range of things that have to be done depending on your industry, what you do, are you providing a service, but we're going to talk about as employer. So based on the size of employer, there are certain requirements for a policy, and then the accessibility plan kicks in when you're a larger employer. So if you're at least 20 employees, you have to file these compliance accessibility reports with the Accessibility Directorate every 3 years in Ontario. There are requirements for the employer piece. There's 5 different sections of AOTA. So the employer part of it, there are different requirements that around issuing the statement that you will allow, or that you will provide accessibility and support for accessibility from hire to fire, basically. So throughout the recruiting process, putting it on your job postings. I think we're all used to seeing this now. Even if you just go buy popcorn at the theater, you'll often see on the window, accessibility. But in the employer environment, statements around the recruitment process. So it has to be on your job postings, job descriptions, in your contracts. We would still highly recommend you include something in there about accessibility. And then right through, if you're doing a PIP, you are expected to talk about accessibility in all of that, for example. So right through to the end. The other things that AOTA does require are documented individual accessibility plans. So if you have anyone in your workplace that you are aware has a disability, you need to have some sort of individual accommodation plan with them in case of an emergency. These are the emergency plans. There are website requirements as well to ensure compliance with AOTA generally. So it's a very detailed legislation, right up to the centimeters of the slant on a ramp into your store, for example. So obviously that's a whole separate webinar for us to go into all the details. It is mandatory. And so if you're an employer in Ontario, you really want to sort this one out if you haven't done so already. The other piece around this is that this does sync up with the Human Rights Code, and it also syncs up with the Employment Standards Act around overall accessibility and non-discrimination. I think that's all for now. Anything you want to add on AOTA, Ben?
No, I think that's a good coverage. Yep.
Yeah. Okay, I'm going to hand it over to Ben for required training.
Okay, so we're going to shift gears a little bit just from the required policies to the training piece. And again, for any, especially comprehensive policies, probably a good idea to provide training, but these are the ones that are strictly required by legislation that we'll be covering today. So first, we're going to talk about occupational health and safety and the associated training requirements from the Occupational Health and Safety Act, and also training on the workplace violence and harassment policy that Lisa spoke about earlier. So first, on the occupational health and safety, the first requirement is that all workers must complete a basic training program, and there's also an additional training program for supervisors. So once again, this is regardless of size of the employer, and these training programs are actually available through the Ontario Ministry of Labour Training and Skills Development. So you can access them through that government website. However, especially for larger employers, if you provide training in-house, and this is something that's covered, you can apply and have your own training program deemed equivalent if that's something that's just easier based on what you have in-house already. The second requirement here, and this will make a bit more sense as we get further in, but there is an additional training requirement for at least one representative of the employer and one worker member of the Joint Occupational Health and Safety Committee to undergo additional training under the Occupational Health and Safety Act that's approved by the Chief Prevention Officer. And this is a role that's also created by the Act. So this is in addition to the basic and the supervisory training that I spoke about, and there are also programs available through the Ontario Ministry that you can find online in terms of whether or not they're approved. But as we note here, it is only required if there's a Joint Occupational Health and Safety Committee, and we'll break this out on a future slide, but the threshold for that would be 20 or more employees in the workplace for that requirement to be necessary. So if you're under that, then this additional training requirement would not strictly be necessary. Moving on to the workplace violence and harassment policy that we spoke about previously, employees must be trained on this policy. It's a direct requirement within the section of the Occupational Health and Safety Act that requires this policy. So very important that this is done. Depending on the size of the employer, it might be a member of management, it could be a member of human resources, or for larger teams, there might be a specific health and safety role within the company, and a person that has that role that might be most appropriate to carry out this training. But again, it is required, and really the idea is that to walk through the policy, explain it, and answer any questions that employees might have, so they're familiar with the process if it's needed for them to bring forward. So that's it on training, but we did want to talk about some additional obligations that were not covered previously in terms of the headings on policies and training. So I'm going to shift to those now. The first being Joint Occupational Health and Safety Committee. Again, I just spoke about this a few minutes ago, but I'll flesh out just what the threshold requirements are for that and what's specifically required under the Occupational Health and Safety Act. And then Lisa will speak to pay equity and the associated obligations with that legislation as well. So first on the Joint Occupational Health and Safety Committee, and I appreciate there's a question on this as well, so we'll make sure to cover this in a bit of detail. And as I noted previously, there was that additional training requirement where a committee is required. And the size of the committee varies by the number of employees. So we've provided a bit of a breakdown here, just so you have a sense based on the size of your organization. So if you have 1 to 5 employees, there's no requirement for a committee or a health and safety representative. If you're 6 to 19 employees, there's still no requirement for a committee, but you do need to have a worker representative that's designed specifically to bring forward any concerns related to health and safety. It's when you get to 20 plus that you have to have an actual committee. And again, this is all required under the Ontario Occupational Health and Safety Act. So if it's 20 to 49 employees in your workplace, you're going to have 2 members, and that would be 1 worker member and 1 representative of the employer. And then if you're 50 plus, you have to have at least 4 members, with half of which, so 2 of course, being worker representatives. Beyond these threshold requirements, there's no actual requirements for form or frequency of meetings, for example. So we don't have any specific guidance on this, but speaking from experience, we often see employers may do something like quarterly meetings. And again, really the purpose of having this committee to start with is to address both proactively and current issues related to safety. So generally, those would be the things discussed in that meeting. Often we see minutes recorded, which is always a good idea for the employer as well to have record of these meetings and any safety issues that either are discussed or especially current ones that are being addressed. So just to provide some brief guidance on that. But again, we talked about previously how certain employers will be much more safety sensitive. Lisa mentioned, for example, construction companies. So, those are the ones where there's probably going to be a lot more on the agenda than, for example, an office environment.
Mm-hmm. Ben, we keep having a ton of questions coming in. So here's a quick one for you. When you say employer on this slide here, can you elaborate what that means? Is it a manager? Can it be HR? What does employer mean?
I assume just in terms of the representative from the employer, just for the committee requirements. Yeah. So that can be anyone that the employer designates. So it's probably going to be a management level person. Like typically the worker representatives would be frontline workers that work for the company. So say you're in a factory, for example, it might be workers that are on the frontline assembly line, whether they're unionized or not. And then for the employer representative, usually that is a member of management, someone that is basically attending on behalf of the company. So it might be a supervisor, it might be a manager of human resources, might even be someone at the director level, just depending on the size and composition of the employer.
And when we are counting employees in this context, does it include independent contractors?
For the committee requirements, yeah. So with occupational health and safety, it would be advisable to include just the employees. Is this strict requirement for that? So we talked a little bit before about the threshold in terms of what's an independent contractor versus an employee. For the committee requirements specifically, it would be just strictly employees that are counted toward that.
Mm-hmm. And then is this still required, this health and safety committee, is it still required in a remote workplace? Is the legislation being adjusted around this? And yeah, it is not yet.
Yeah, no, it's not yet, and I appreciate that it is a bit awkward. So it is still required. The same requirements would apply in terms of the threshold. And again, it's there's no specific requirements for form or content. So if you're an office environment that's remote and maybe there's not a lot of safety issues, there's always the flexibility to cut down on the frequency of meetings. But what that would likely look like is you would have virtual meetings, of course, to meet and discuss those issues, but the requirements would still apply to have the committee.
So much of health and safety from a legal point of view is all about due diligence. So, and policies in general, right? It's having, it's the act of having the meetings. It's the act of keeping everyone apprised of what policies exist. It's dusting them off, at least annually to make sure everybody knows about the policy. Because if something happens in your workplace and an employee is able to say, well, I didn't know that was a policy, or I didn't know about this, or we never talk about this, or the employer doesn't take safety seriously because we never have these meetings. It's so nice for you to pull out some minutes of these 10-minute meetings you have every quarter where you have a very brief agenda, everyone's happy, it's tickety-boo, and then you all go on your merry way. But at least you've turned your mind to it. I think that's the key piece. That is the heart of due diligence. It's turning your mind to it in a recurring pattern that you can point to if something goes wrong. I think we have, okay, there was another question here. I knew I skipped one. Can we include workplace harassment training as part of onboarding training? Should we provide individual training and evidence for this? Great question. So yes, you're onboarding, hopefully you have a nice detailed checklist when you're onboarding an employee from an HR perspective. And because it's mandatory that people, not just, especially that the workplace violence and harassment obligations, the policies are mandatory, which means that the employees need to know about it. So I would absolutely bake that into your onboarding, that there's a list of these mandatory things that they are told about and pointed to. Ideally have them sign off that they've read it. And all that can be through exchanges of email. You don't need anything overly fancy about it. But some sort of record that they have received and are agreeing that they have read the policy is a key thing that it's good to have in your records. Okay, it's 11:15. We better keep going here. Pay equity. So this is the other mandatory obligation in Ontario if you are a certain size. So pay equity is like a whole week seminar unto itself. So I definitely am not going to go into a ton of detail here. But if you are there are different thresholds of obligations. Under 10, there are no obligations. Between 10 and 99, there are some, and then above 100 employees is where a lot of it really kicks in. So the point of pay equity is to conduct job and pay rate comparisons for all genders in each job, using each job class. So you're comparing apples to apples all the time, and really thinking through if this is a role that's similar to this kind of role over here, even if it's or similar level, it doesn't need to be the same role, but this is predominantly female, this is predominantly male. Let's look at the pay and see if we're underpaying the women, which statistically you likely are. And so it's trying to bring pay equity across the board regardless. And this has been a really very important piece of legislation for women over the years. You know, a classic example is the janitor and the secretary in a company would get the same pay. Or the secretary would get less than the janitors, right? Because this historically tended to be male, this tended to be female. And so trying to really think through, are these jobs the same? So it is a really complicated process. There are experts in pay equity that will pull out all the various spreadsheets and tools to help you do this analysis and adjust the compensation so that underpaid genders in each job class are paid at least as much as their comparable role in a comparable job class. It applies to all public sector, and then all of the requirements are applied to 100 and over. Pay equity and gender discrimination, obviously that's all also covered under the human rights codes across the country, of course. And then the ESA also has some sections that address this, you know, things like benefits, and, you know, there's certain sections that speak to this as well. So gender equality, you know, it's covered across a few things. Pay transparency has come out over the last few years, and we just included a bullet here to distinguish what's the difference between pay transparency and pay equity. Pay equity is mandatory in Ontario. Pay transparency is a piece of legislation that has been passed but has not been put into effect yet. So it's sitting there ready, waiting to go. And so it is it's a piece of legislation that I mean, this is the world of politics, I think. But the pay transparency is all about employers being prohibited from asking a candidate, for example, what they got paid in their last role. Because what will historically happen then is that women who statistically are very underpaid to their male counterparts still will cite, okay, well, I had 100,000 last year, but then, you know, her equivalent at that company maybe had 110. So now at this new employer, they're going to pay her a little bit more than 100 to, you know, bring her over. And it's just perpetuating this underpaid gender discrimination across the board. So pay transparency is designed to try and address that. It also has requirements such as putting salary ranges on job postings so that there's transparency, so that it truly is merit and not gender that's driving the salaries. Because pay equity has been great, but it hasn't fixed it yet. Statistically, it's still a big problem that women are paid less than men across all industries at this point. Still a little bit depressing, since pay equity is a much older act and we still haven't solved the problem. In the interest of time, I'm going to move on to the next section. I feel like I cut short the pay equity details, but I want to make sure we cover the other items as well. So I'm going to pass it back over to Ben to talk about the required mandatory postings in the workplace.
Okay, so we're going to shift again. We've covered policies, training, and ongoing obligations as well. So the final topic is the required postings, and again, those that are strictly required by legislation. So I'll just quickly run through these. They are accessible online, and if you have any questions about how to locate them, we can certainly help with that. The first one is the Employment Standards Poster. Again, this is a posting developed by the government to provide information on the Ontario Employment Standards Act. The second being Occupational Health and Safety Poster, as well as the Occupational Health and Safety Act. Just picking up on that same source from the Occupational Health and Safety Act, you need the health and safety policy that we spoke about, posted as well, including the workplace violence and harassment policy that we spoke about in terms of the requirement for a policy and the training. There's also a workers' compensation poster that must be provided as well. And the ones I've spoken about so far will be required regardless of size of the workplace. The rest of them will depend. So pay equity plans will apply based on the size of the employer and which obligations apply that Lisa spoke about today. There is a posting requirement for WHMIS as well, but this would be for employers who store hazardous products on site. So of course not going to apply to everyone. And finally, there's a piece of legislation called the Smoke-Free Ontario Act 2017. And there's a posting required for this if the employer has an enclosed workplace. So if everyone's virtual, or for example, if the work is performed outside, just to provide a few brief examples, this may not apply. So the final three are basically optional and may or may not apply to your workplace. Picking up on a question that Lisa addressed earlier, we realize, especially now that there's more virtual work happening, there may not be a physical workplace to post these in. So we talked about onboarding. There's a good opportunity there to provide any required postings up front to the employee for transparency. And there's also likely some type of internal system, whether it's a drive or some type of internal database where these can be housed. So at least there's an opportunity after onboarding where the employees can go there and access them at all times.
We just got a question. If we occupy several floors within one building, are postings required on all floors or only in a certain place or certain places?
The wording that most of the legislation uses, whether it's employment standards or the Occupational Health and Safety Act, is a conspicuous place, So really what that means is a place where employees will see it. So I guess if you consider that from the perspective of a larger workplace, employees on one floor may have no reason to go to another floor, then at a precaution you could post it on both. But if the space is quite shared and there's a designated area where all postings go, or there's a lunchroom that everyone shares and that's where postings are typically located, that would be a situation where we would say it's very likely fine to put them in the one place. And again, you can always put these as well on an internal drive as a backup as well, even if you have the physical workplace.
Mm-hmm. Okay, we're going to shift gears now and talk about next steps, because I think what we're trying to do is really zero in and focus in on the must-haves and the legally mandatory pieces, knowing that everyone is always short for time, and trying to make it more clear about what noise can we cut out. So for your next steps, I would say that auditing the gaps is the key thing. Really identifying what are the core must-haves, and then identify the gaps, prioritize based on your industry, on your workplace, on sort of doing your own internal risk assessment. Identify what internal or external resources are available so that you can start identifying and addressing the different gaps. And then chip away at it. I mean, this is the advice that we give. We have a subscription program, so we when we're working with employers and building out the game plan for them over the year about what priorities are. Rome was not built in a day, so chipping away at it, a little bit at a time. They are legally mandatory, so I'm not suggesting to hold off, but it realistically, they weren't in yesterday. If they're not in today, it's okay, but get them in tomorrow, kind of thing, and prioritize what needs to happen. As a help that we have pulled together from our firm is a compliance program we have that we've put in place that tries to pull in all of the mandatory items that employers need. So it's an offering that we have for 2024. I think post-COVID, we were just hearing so much feedback from clients that there's just it was exhausting keeping up with all the COVID change over and over and over. And so we're trying to all regroup and simplify. So this compliance program that we've rolled out this year, it has several components. The mandatory HR law piece of auditing your policies, helping draft them for you, and really building out your 2024 plan to get everything in place. Part of it also is having your hiring, your contracts and your termination documents vetted and good to go, because although that's not compliance, that's part of the core legal infrastructure that every employer really needs as a top priority of cost savings. And then we set everyone up with a quarterly compliance call. That it's a one-on-one with one of the lawyers here at Springlaw to just help you stay on track and answer any questions and just really zero in on the core offerings that you need. So that's our compliance program. If you're interested at all, come to our website. Ben, over to you for key takeaways.
Yeah, so as Lisa mentioned, Rome definitely was not built in a day. We appreciate it's a lot. We've talked about required policies, required training, some additional obligations under occupational health and safety and pay equity, and the mandatory postings. So like Lisa mentioned, it's good to do an assessment first, figure out where you're at in your workplace, and then from there, determine a game plan. It can't all be done in one day, but it would be a good idea to, since these are required under legislation, to figure out where you're at in your workplace, where are the areas that you need to target to deal with some of this liability, and work from there, and reach out if there's any questions. And we're happy to help work through that, because we do appreciate that this is not something that you want to take up a lot of your time when you're busy trying to run the business. So
we have a free HR compliance checklist. If that's useful, come to our website and you can download that to try and help give yourself a bit of a start on that. And that, I think, is all for today. I know there's a few questions that we didn't get to, so for the people who sent them in, feel free to follow up with us. We're happy to continue the conversation with you. That concludes our webinar for today. Our next webinar is going to be on March 20 at 10:30 a.m., as it always is, the third Wednesday of the month. We are finalizing we're having a guest on there. We're finalizing it, so we'll do the big reveal on our social shortly, but it's going to be mostly, we're hoping this one will be about cross-border and remote worker issues. So please feel free to follow up with any questions you may have. For more information, please come to our website, springlaw.ca, to learn more about that compliance program, grab your free checklist, sign up for our legal updates for our newsletter or these monthly webinars. Please follow us on social. We're all over: Facebook, Twitter, LinkedIn, Instagram, TikTok, our YouTube channel. And then please join us next month, and we look forward to seeing everybody. Thank you very much for today. Thanks, Ben.
thanks, everyone.